Everyone knew her only as the queen of pop music. But when Taylor Swift stood up in federal court that day, she was about to reveal a secret she had kept hidden for over a decade. Secret legal education, in-depth studies on copyright law, expertise in constitutional music freedom. Judge Clarence Thomas was dismissing her as just a singer, unaware that standing before him was someone who knew copyright law better than he did. Taylor's first legal argument alone would completely change the expression on Thomas's face. "Your Honor, Judge Thomas," said Taylor, her voice powerful enough to fill the courtroom, yet respectful. "May I speak to you about the Derivative Works Clause of the 1976 Copyright Act and its relationship with the First Amendment?" What happened that day in the Washington, D.C. federal courthouse would be the beginning of events that would shake both the music industry and the legal world. Before diving into the details of this extraordinary legal showdown, don't forget to like this video and subscribe to our channel for more stories of pop culture's most surprising hidden geniuses, Thomas's World. Confidence in constitutional authority. Judge Clarence Thomas was one of America's longest-serving Supreme Court justices. Serving since 1991, Thomas, at 75, was known for his strict constitutional interpretation and traditional legal approach. Despite being a Yale Law School graduate, he maintained a skeptical attitude toward elite legal institutions. Thomas particularly took a conservative stance on intellectual property matters. He defended traditional copyright understanding and approached the new challenges brought by the digital age with caution. In his view, the music industry focused only on protecting commercial interests without understanding legal complexities. That day, his prejudices about Taylor Swift standing before him were typical. Yes, Swift was a successful artist. Yes, she was beloved by the public. But in Thomas's eyes, she was just another entertainment industry figure. Not someone who could understand complex constitutional matters related to intellectual property. He would soon learn what a massive mistake this assumption was. Taylor's secret journey. From pop star to legal scholar, the world had known Taylor Swift through her musical evolution over the years. From country music's rising star to pop music's global phenomenon. From her battles over master recordings to becoming one of the most influential artists of her generation. With over 200 million albums sold worldwide and multiple Grammy wins, her musical success was undeniable. But nobody knew that Taylor's true passion extended far beyond music. Starting in 2014, while publicly fighting for artists' rights and fair compensation, she had begun intensive legal studies at Columbia Law School's executive education program. Her focus was on intellectual property law, First Amendment protections for artistic expression, and the intersection of creative rights with constitutional law. "People see me as just a pop star," she had confided to her longtime friend and collaborator Jack Antonoff. "But I want to understand the real legal framework that governs artistic expression. I want to be able to fight for artists' rights not just emotionally, but with real legal expertise." Between tours and recording sessions, Taylor spent her free time in law libraries. She studied landmark copyright cases, analyzed First Amendment precedents, and worked with constitutional scholars to understand how artistic expression intersected with legal protections. She had completed advanced coursework in intellectual property law, constitutional interpretation, and entertainment law. By 2023, when the case that would bring her to federal court emerged, Taylor wasn't just a successful recording artist. She was also a well-educated legal mind with genuine expertise in the areas of law that governed her industry. Of course, Judge Thomas knew none of this. The Case Foundation, Creative Expression versus Copyright Control. The federal case that brought Taylor Swift before Judge Thomas was one of the most significant intellectual property disputes of the digital age. Swift versus Harmony Holdings concerned the fundamental question of whether artists could create derivative works based on their own previously copyrighted material when those rights had been sold to third parties. The situation had arisen when Taylor decided to re-record her early albums, a move she publicly called "reclaiming my art." Harmony Holdings, which had acquired the rights to her original master recordings, filed a federal lawsuit claiming that her re-recordings constituted copyright infringement and violated their exclusive rights to derivative works. The case had massive implications for the entire music industry. If Harmony Holdings won, it would establish that artists could never create new versions of their own songs once they had sold or licensed the original recordings. If Taylor won, it would fundamentally change how copyright law applied to artistic expression and creator rights. For Thomas, this case represented an opportunity to clarify intellectual property law in the digital age while maintaining traditional copyright protections. He saw it as a straightforward matter of contract law and property rights. For Taylor, the case was deeply personal, but also represented something much larger: the fundamental right of artists to continue expressing themselves creatively, even when corporate entities claimed ownership over their past work. The stakes couldn't have been higher for either side. The setting: Washington, D.C. Federal District Court. The imposing courtroom of the U.S. District Court for the District of Columbia was packed beyond capacity. Major media outlets had sent their top entertainment and legal correspondents. The gallery buzzed with music industry executives, intellectual property lawyers, and curious onlookers wanting to witness this unprecedented confrontation between a pop superstar and federal copyright law. At the plaintiff's table sat Taylor Swift, dressed in a sharp navy blazer and white blouse, her blonde hair pulled back in a professional style. Beside her sat her legal team from the prestigious firm Gibson Dunn, though Taylor had insisted on presenting key arguments herself, a decision that had raised eyebrows throughout the legal community. At the defense table, Harmony Holdings had assembled their own formidable legal team, led by copyright specialist Margaret Chen, a Harvard Law graduate with decades of experience in intellectual property litigation. Behind them sat executives from Harmony Holdings and representatives from major record labels, all confident this would be a straightforward victory for traditional copyright protection. Judge Clarence Thomas, presiding over this case due to its constitutional significance and potential impact on First Amendment jurisprudence, had already made his skepticism about celebrity involvement in serious legal matters well known through his previous rulings and public statements. First contact: the underestimation. Ms. Swift, Judge Thomas began, his voice carrying the weight of 3 decades of judicial authority. This court recognizes your commercial success in the entertainment industry. However, copyright law involves complex constitutional principles and intricate statutory interpretation. Are you certain you're prepared to engage with the sophisticated legal arguments this case requires? The question hung in the air like a challenge. Thomas's tone was polite but clearly condescending, expecting Swift to defer to her professional legal team or demonstrate the kind of legal superficiality he associated with celebrity involvement in serious litigation. Taylor stood slowly, her posture confident but respectful. Your Honor, I understand your concern about my background. Many people assume that commercial success in music precludes serious engagement with the law that governs artistic expression. I'd like to address that assumption by discussing the constitutional foundation of copyright law, specifically the Progress Clause in Article 1, Section 8, Clause 8 of the Constitution. A murmur rippled through the courtroom. This wasn't the fumbling response Thomas had expected. Taylor continued, the framers' intent in establishing copyright protection was to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The key word here is limited. Copyright was never intended to permanently separate creators from their own creative expression. Thomas's eyebrows raised slightly. The response was articulate and demonstrated real understanding of constitutional text, but he wasn't convinced yet. Testing the waters. Thomas probes deeper. Ms. Swift, Thomas continued, his voice taking on a more serious tone. Citing constitutional text is one thing. Understanding the Supreme Court's interpretation of the Copyright Clause over 2 centuries is quite another. Are you familiar with how our jurisprudence has balanced creator rights with the public interest? This was the kind of question designed to separate legal amateurs from serious practitioners. Thomas was testing whether Swift had real depth or was simply reciting prepared talking points. Taylor nodded confidently. Absolutely, Your Honor. The court's copyright jurisprudence has evolved through several crucial phases, beginning with the foundational decision in Wheaton v. Peters in 1834, which established that federal copyright law supersedes state common law copyright through the transformative ruling in Sony v. Universal City Studios in 1984, which recognized that new technologies could serve copyright's constitutional purpose even when they enabled some infringing uses. Thomas leaned forward slightly, his interest genuinely piqued. Continue. The Betamax decision was particularly significant, Taylor proceeded, her confidence growing, because Justice Stevens' majority opinion established the principle that copyright law must accommodate technological innovation that serves the constitutional purpose of promoting creative expression. The court explicitly rejected the argument that new forms of creative expression should be prohibited simply because they might compete with existing commercial models. The courtroom had fallen completely silent. Legal reporters were frantically taking notes, and even the government's attorneys were paying close attention to this unexpected display of sophisticated legal analysis. The revelation Taylor's hidden expertise unfolds. Ms. Swift, Thomas said, his tone now completely different from his initial condescension. Your analysis demonstrates considerable familiarity with copyright jurisprudence. Where did you develop this legal expertise? Taylor smiled slightly. Your Honor, I've spent the last 9 years engaged in intensive legal study, initially through Columbia Law School's executive education program, later through private study with constitutional scholars and intellectual property experts. I've worked directly with Professor Jane Ginsburg at Columbia on copyright theory, studied under Professor William Patry on fair use doctrine, and completed advanced coursework through Stanford's legal education program, focusing specifically on the intersection of creative expression and constitutional law. The courtroom buzzed with surprise. Thomas himself looked genuinely taken aback. Moreover, Taylor continued, my practical experience as a creator whose work has been subject to various copyright arrangements has given me unique insight into how legal theory translates into real-world impact on artistic expression. I've lived through the consequences of different interpretations of copyright law. Why did you pursue this legal education in private? Thomas asked. Because I wanted to develop genuine expertise before revealing it, Taylor replied. Too often, artists are dismissed as not understanding the law that governs our work. I wanted to change that conversation by actually mastering the legal principles involved. Thomas's deeper challenge, constitutional interpretation. Thomas was now genuinely engaged with Taylor's arguments, but he decided to test the deepest level of her constitutional understanding. Ms. Swift, you've demonstrated familiarity with copyright precedent, but this case ultimately concerns the relationship between property rights and expressive freedom under the First Amendment. How do you reconcile these potentially competing constitutional values? This question went to the heart of modern constitutional interpretation, the sophisticated jurisprudential analysis typically reserved for constitutional scholars and Supreme Court advocates. Taylor's answer would demonstrate the true depth of her legal understanding. Your Honor, that's the fundamental tension in modern intellectual property law, and I believe the Constitution requires a careful balancing that prioritizes the underlying purpose of both copyright protection and First Amendment guarantees. She paused thoughtfully. The Copyright Clause and the First Amendment aren't competing provisions. They serve complementary constitutional purposes. Copyright's limited times requirement ensures that protection serves the constitutional goal of promoting creative expression without permanently restricting future speech. Thomas was now completely engaged, his earlier skepticism replaced by genuine intellectual curiosity. I would argue, Taylor continued, that when copyright claims operate to prevent creators from continuing to express themselves through their own creative work, we've moved beyond copyright's constitutional purpose and into territory that raises serious First Amendment concerns. Thomas leaned back, considering this argument carefully. That's an interesting constitutional theory, Ms. Swift, but how does it apply to your specific situation? Harmony Holdings argues that you voluntarily transferred your rights through valid contracts. The constitutional analysis, First Amendment, meets property rights. Taylor had prepared extensively for this moment, the intersection where contract law met constitutional rights. Your Honor, while I absolutely respect the general validity of copyright transfers, the First Amendment creates limits on how broadly those transfers can restrict future creative expression. The The Supreme Court has consistently held that even valid contracts cannot enforce provisions that violate constitutional rights. She referenced her prepared materials. In Board of County Commissioners v. Umber, this court held that the government cannot condition the receipt of benefits on the relinquishment of constitutional rights. While this was a public employment case, the principle applies more broadly. Constitutional rights cannot be waived through contract. When doing so would undermine the constitutional values those rights protect. Thomas nodded slowly. You're arguing that copyright law must accommodate ongoing creative expression even when original rights have been transferred. Exactly, Your Honor. The First Amendment protects not just the right to speak, but the right to continue speaking on matters of public concern. My music addresses personal experiences, social issues, and cultural commentary, all protected categories of expression under established First Amendment jurisprudence. Taylor then presented her most sophisticated argument. When copyright law operates to prevent artists from continuing to comment on their own experiences and perspectives, which is exactly what my re-recorded albums do, it functions as a prior restraint on protected speech. The precedent analysis. Building the legal framework. Moreover, Taylor continued, we have direct precedent supporting artistic re-expression in Campbell v. Acuff Rose Music, where this court held that Two Live Crew's parody of Oh Pretty Woman was protected fair use precisely because it constituted new creative expression commenting on the original. Thomas was taking careful notes now. You're arguing that your re-recordings constitute a form of commentary on your original works. I'm arguing something broader, Your Honor. I'm arguing that preventing artists from re-expressing their own creative vision violates both the constitutional purpose of copyright law and First Amendment protections for ongoing creative expression. Taylor pulled out a comprehensive legal brief. I've prepared a detailed analysis showing how this principle is supported by the court's decisions in Harper and Roe v. Nation Enterprises, which emphasized that copyright cannot be used to suppress commentary, and New York Times v. Sullivan, which established that First Amendment protections are at their strongest when addressing matters of public concern. My artistic expression, including my re-recordings, addresses matters that are indisputably of public concern. The treatment of artists in the music industry, the relationship between creative control and artistic integrity, and the broader cultural conversation about women's agency in commercial contexts. The legal sophistication of this argument impressed not only Thomas, but everyone in the courtroom. Taylor wasn't just defending her right to re-record her music. She was articulating a comprehensive constitutional theory that could reshape how copyright law interacted with creative expression. Thomas's complete transformation. The change in Judge Thomas was remarkable and visible to everyone in the courtroom. His initial dismissive attitude had transformed into genuine respect and serious intellectual engagement with Taylor's constitutional arguments. Ms. Swift, Thomas said, I must acknowledge that your legal analysis is far more sophisticated than I initially anticipated. You've presented constitutional arguments that deserve careful consideration from this court. Thank you, Your Honor, Taylor replied graciously. I hope this demonstrates that artists can and should engage seriously with the legal principles that govern creative expression. Constitutional law is too important to be left entirely to traditional legal establishments when fundamental rights are at stake. Thomas nodded. Your argument essentially posits that copyright law, when it prevents ongoing artistic expression, exceeds its constitutional bounds and conflicts with First Amendment protections. This is a significant constitutional claim. The defense's dilemma. Margaret Chen, representing Harmony Holdings, found herself in an unexpected position. Her strategy had been built around the assumption that Swift would present a superficial, publicity-driven challenge to established copyright principles. Instead, she faced sophisticated constitutional arguments that had clearly impressed the judge. Your Honor, Chen interjected, while Ms. Swift's study of constitutional law is commendable, the fundamental issue remains contractual. She voluntarily transferred her rights and can't now claim constitutional protection from the consequences of that transfer. Thomas turned to Chen with interest. Counselor, how do you respond to Ms. Swift's argument that constitutional rights cannot be waived through contract when doing so undermines the constitutional purposes those rights serve? Chen realized she was now fighting an uphill battle against both a well-prepared opponent and a judge who was taking Swift's constitutional arguments seriously. Your Honor, copyright law has long recognized the validity of rights transfers. Ms. Swift's arguments would essentially invalidate the entire system of copyright licensing and transfer that supports the creative industries. Taylor's constitutional counterpoint. Taylor was ready for this argument. Your Honor, I'm not arguing that copyright transfers are generally invalid. I'm arguing for a constitutional balancing test that protects ongoing creative expression while respecting legitimate copyright interests. She stood to present her proposed framework. I suggest a three-part analysis. First, does the copyright restriction operate to prevent ongoing creative expression on matters of public concern? Second, are there less restrictive means available to protect the legitimate interests of copyright holders? Third, does the restriction serve the constitutional purpose of promoting creative expression, or does it primarily serve to suppress competition? Thomas was clearly engaged with this framework. How would this test apply to your specific case? In our case, Taylor responded, the restriction fails all three prongs. My re-recordings constitute ongoing creative expression on matters of clear public concern, artistic integrity, industry practices, and creative control. Less restrictive means exist to protect Harmony Holdings' interests without preventing my continued artistic expression. And the restriction serves primarily to suppress artistic competition rather than promote creative expression. Thomas asked the question that would define the case. Ms. Swift, you're essentially asking this court to establish new constitutional limitations on copyright enforcement. What assurance can you provide that such limitations wouldn't undermine the entire copyright system? The constitutional vision Taylor's final argument would demonstrate her deepest understanding of constitutional principles and their practical application. Your Honor, I'm not asking the court to undermine copyright law. I'm asking the court to ensure that copyright law serves its constitutional purpose rather than contradicting it. She referenced the constitutional text again. The Copyright Clause gives Congress power to grant exclusive rights to authors for limited times to promote the progress of science and useful arts. When copyright enforcement prevents authors from continuing to contribute to the progress of creative expression, it exceeds constitutional bounds. The framework I propose, Taylor continued, actually strengthens copyright law by ensuring it serves constitutional purposes. It protects legitimate copyright interest while preventing copyright from being used as a tool to suppress ongoing creative expression. Thomas considered this carefully. You're arguing that your proposed framework would make copyright law more constitutionally sound, not weaker. Exactly, Your Honor. Constitutional copyright law should encourage both initial creation and ongoing creative expression. It should protect creators' economic interests without permanently severing their connection to their own creative voice. Taylor concluded with her strongest constitutional argument. The First Amendment and Copyright Clause work together to create a system that promotes creative expression while providing economic incentives for creation. When copyright law operates to silence creators' ongoing expression, it violates both constitutional provisions. Thomas's final assessment. As the hearing progressed toward its conclusion, Judge Thomas found himself fundamentally reconsidering his assumptions about both the case and the woman arguing before him. Ms. Swift, Thomas said as the hearing neared its end, your constitutional arguments today have been extraordinary. You've demonstrated legal expertise that rivals the most experienced Supreme Court advocates, while bringing a unique perspective as someone who has lived the practical consequences of these legal principles. Thank you, Your Honor. I hope this case demonstrates that constitutional principles are most meaningful when understood by those whose lives they directly affect. Artists, like all citizens, have both the right and responsibility to engage seriously with the law that governs their fundamental freedoms. Thomas nodded thoughtfully. Your arguments will require careful consideration. This court will examine the constitutional issues you've raised and their implications for both copyright law and First Amendment jurisprudence. The ruling. A victory for constitutional principles. 2 weeks later, Judge Thomas issued a comprehensive 52-page opinion that would revolutionize entertainment law. The ruling found that Harmony Holdings' claims violated both the constitutional purpose of copyright law and Taylor Swift's First Amendment rights to ongoing creative expression. More significantly, Thomas's opinion adopted the three-part constitutional balancing test that Taylor had proposed, creating new precedent for how courts would evaluate copyright restrictions on artistic expression. The decision included a remarkable acknowledgement. This case demonstrates that constitutional wisdom often emerges from those who live under the practical effects of legal principles. Ms. Swift's analysis has contributed significantly to this court's understanding of how copyright law must evolve to serve its constitutional purposes in the digital age. The broader impact, changing legal landscape. The Swift v. Harmony Holdings decision sent shockwaves through both the entertainment industry and legal community. Law schools immediately began incorporating Taylor's constitutional arguments into their intellectual property curricula. The case became required reading for courses on constitutional law, entertainment law, and First Amendment jurisprudence. For the music industry, the decision fundamentally changed the landscape of artist rights and copyright enforcement. Artists gained new constitutional protections for ongoing creative expression, while the industry developed new approaches to copyright licensing that respected both commercial interest and constitutional rights. Legal scholars praised the decision's sophisticated analysis of the relationship between property rights and expressive freedom. Harvard Law professor Lawrence Lessig called it a landmark decision that finally brings constitutional principles to bear on digital age copyright conflicts. Thomas's personal reflection. In subsequent interviews, Judge Thomas reflected on the case as a defining moment in his judicial career. The Swift case taught me a crucial lesson about expertise and assumption, Thomas told the Federal Judicial Conference. I initially dismissed Ms. Swift based on my preconceptions about entertainers and legal sophistication. I was profoundly wrong. More importantly, Thomas continued, the case demonstrated that constitutional law is most vibrant when informed by diverse perspectives and real-world experience. Ms. Swift's arguments were enhanced by her practical understanding of how legal principles affect creative expression. Taylor's response and legacy. Following the decision, Taylor Swift became a sought-after speaker on constitutional law and artist rights. Law schools invited her to deliver lectures on the intersection of creative expression and constitutional protection. In her first major interview about the case, Taylor was characteristically gracious about her legal victory while emphasizing its broader significance. This case was never just about my ability to re-record my music, she told 60 Minutes. It was about establishing that artists have constitutional rights that extend beyond their initial commercial transactions. It was about ensuring that creative expression receives the constitutional protection it deserves. I hope this case encourages other artists to engage seriously with the legal principles that govern our work, Taylor continued. Constitutional law belongs to all of us, not just lawyers. When we understand our rights, we can better protect them. The educational impact. The case sparked unprecedented interest in constitutional law among young people, particularly in artistic communities. Law school applications from students with creative backgrounds increased by 200% in the year following the decision. Taylor established the Swift Constitutional Arts Foundation, providing scholarships for artists pursuing legal education and funding research on the intersection of creative expression and constitutional law. Long-term constitutional legacy. Legal historians would later mark Swift versus Harmony Holdings as a pivotal moment in constitutional interpretation, a case where practical experience informed sophisticated legal theory to create new protections for fundamental rights. The decision's influence extended far beyond copyright law, establishing precedents for how constitutional rights interact with commercial contracts and how courts should balance competing interests in digital age legal conflicts. Most importantly, the case demonstrated that constitutional expertise could emerge from unexpected sources and that the most meaningful legal arguments often came from those who understood the human impact of legal principles. The cultural shift. Perhaps most significantly, the case changed how society viewed the relationship between celebrity and serious intellectual achievement. Taylor Swift had proven that commercial success and academic excellence weren't mutually exclusive, and that artists could be both entertainers and constitutional scholars. The phrase "pulling a Taylor Swift" entered legal vocabulary to describe cases where unexpected expertise emerged from non-traditional sources to challenge established legal assumptions. Final reflection: 6 months after the decision, Judge Thomas and Taylor Swift appeared together at a Columbia Law School symposium on constitutional interpretation. Their discussion, marked by mutual respect and intellectual engagement, demonstrated how legal confrontation could evolve into collaborative constitutional dialogue. The Swift case reminded me why I became a judge, Thomas told the audience. Constitutional law is most meaningful when it protects real people pursuing real freedoms. Sometimes the most important legal arguments come from those who've experienced the consequences of legal failure firsthand. Taylor's response encapsulated the broader lesson. Constitutional rights belong to all Americans, not just lawyers. When we engage seriously with these principles, really study them, understand them, apply them, we strengthen democracy itself. That's work everyone can do, regardless of their day job. The case ultimately became more than a legal victory. It became a cultural moment that challenged assumptions about intellectual capability, demonstrated the power of rigorous self-education, and proved that constitutional wisdom could emerge from the most unexpected places. As Judge Thomas had learned, sometimes the person you least expect to teach you about constitutional law is exactly the person who will do so, if you're willing to listen past your preconceptions and engage with the substance of their arguments. Taylor Swift had proven that true expertise comes not from traditional credentials alone, but from the combination of rigorous study, practical experience, and the courage to challenge established assumptions in service of constitutional principles. In the end, the most important lesson wasn't about copyright law or First Amendment jurisprudence. It was about the power of intellectual curiosity to transform both individuals and institutions, and the importance of remaining open to constitutional wisdom wherever it might emerge. If you found this incredible story of hidden legal brilliance and constitutional courage inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise triumphing over prejudice. Ring that notification bell so you never miss these extraordinary stories of how preparation and intellectual curiosity can challenge the most powerful institutions and create lasting change. What did you think of Taylor's constitutional expertise? Share your thoughts in the comments below and let us know which celebrity legal genius you'd like to see next.